Well, good morning, everyone, and thank you for joining us. My name is Michael Gault. I'm an eminent domain attorney with Bell Carrington, Price and Gregg, and along with Lindsay Carrington, an attorney in our office, we're excited to come to you today to offer this virtual town hall to talk about the NC 107 project in and around Sylva. If you're here with us today, you're likely here because of a link in a mail piece that we sent to you. If you receive that, then there's all indications are, at least from our end, that you're going to be impacted by this project. And so we just wanted to take a few minutes to hop on here to tell you a little bit about this project in general, about the eminent domain process in general, and just to go through some things with you in a generalized setting. Now, we can't offer any legal advice in a virtual town hall like this, but later on in this call, you'll see my name, information, phone number, and email address. Feel free to reach out to us, and someone with your team will be standing by, with our team will be standing by to speak with you on a more detailed basis, on a one-on-one basis about this project and its particular impact to your property. So let's just get started talking briefly and generally about the project. If you live or work in the area, then there's a good chance that you've been hearing about this for some time now. The first public meetings occurred 4 or 5 years ago. There were a number of plan changes and preliminary design changes. And ultimately, we're to a stage now where right-of-way acquisition is really about to begin. We know from working with some current clients along this project that they've at least been contacted preliminarily by the DOT or a third-party representative regarding that right-of-way acquisition. And so we would expect that if you haven't been contacted already, that contact will really start ramping up over the coming weeks to coming months. I know that many of you, probably based on the public information, expected that right-of-way acquisition to begin last year or even in 2020. Unfortunately, or perhaps fortunately, depending on which side you're on, that acquisition was pushed back for a number of reasons, along with the overall timeline of the project. But what it looks like now is that right-of-way acquisition will happen between now and this summer. It'll be a lengthy process because of the size of the project, but then with some construction starting in 2024 and next year. So this project, generally speaking, is running along 107 all the way from 23 Business down to south of 116 and Fairview Road. The project is significant. There's widening of the roadway, the addition of pedestrian and bicycle lanes, and various safety improvements at every intersection along the way. Looking at this project, and as all of you know, this is a very commercial heavy corridor, lots of businesses up and down this section of 107. And so for that reason, the impact is going to be greater for many of you than it would be for a residential parcel that would be along the same sort of stretch. Through the eminent domain process, the government has the right to take private property for a public purpose. That is eminent domain in a nutshell. But that doesn't mean that you as landowners also have rights. You do. Among the most important of those rights is what we call the right to just compensation, which basically means that although the DOT likely in this case has the right to take the property that they need to complete the build, they also have to compensate you fairly and adequately for what they're looking to take from you. And that's not always clear cut and simple. At some point, the DOT is going to come to you with an appraiser or with an offer and say, hey, we think you're impacted. Here's how we think you're impacted, and here's what we're going to offer you. But it's important for you as a landowner to know that that's not the end all be all. That's not an offer that you have to accept, because oftentimes that offer may miss something. It may miss the valuation to the land or to the property or to the improvements on that property. It may miss what we call damages to the remainder, which is something that is often overlooked by the condemnor in a case like this or in a project like this. And it's important for you as a landowner to catch it and to recover for it on the front end, because you really only get one bite at the apple. Once this project is complete, let's say you settle early on with the DOT and the project is complete 2 or 3 years from now, and you really see something that is impacting your property drastically that you didn't catch the first time and that the DOT didn't warn you about. If you've already settled, then it's too late to come back and ask for more money for those additional damages that you discover later on. And so that's sort of where we come in. We help our clients landowners and business owners to evaluate the impact to the property and ultimately to negotiate and work through the condemnation process to make sure that our clients are protected at the end of the day. One thing that I see that may impact many of you business owners along this stretch of 107 is the change from what we would call full access to right in, right out access only, meaning that for many of you, there will be guardrail or raised concrete median that would prevent the public, prevent customers, invitees from making left turns into your property and left turns out of your property. Everything will have to flow right in and right out. And that causes some problems depending on the nature of your business or the nature of your location. It's always more beneficial to have full access, right in, right out, left in and left out. And so it's important for you to look at that and allow us to look at it with you to see if that's something that should be of concern on your particular property. And if so, how we may be able to help you going forward. The process in general, we mentioned that initial negotiation. If that's unsuccessful, eventually we get into what is known as a condemnation proceeding, which is basically a legal proceeding whereby the government, in this case, the DOT, will file a document that giving them the legal right to enter into the property for purposes of construction. That doesn't mean that the negotiation is over. In fact, it still continues through the court system up until and eventually even possibly a jury trial. That's not likely. Very few cases go to trial these days, but there's a chance that it may. And ultimately, if we're unsuccessful with our negotiation through the pre-condemnation process and even in the condemnation process, that's a right that you have as a landowner later on. A couple of other quick things that I'd like to mention to you. Obviously, as I said, this forum is for some generalized information, but we would welcome the opportunity to speak with you one-on-one. Our consultations at Bell Carrington are always free. They're always no obligation regarding eminent domain cases. You're not going to be on the hook with anything with us. We just want to have the chance to speak with you, to learn more about your property, to learn more about your impact, and to see if we may be able to help you. And that's what we love to do. I focus on eminent domain matters. Our team focuses on eminent domain matters throughout the Southeast. And so we're standing by ready and waiting to speak with you about your property to see if you're impacted. Fortunately, during those initial consultations, we have access to some proprietary in-house software that allows me in real time to pull up your property and the impact to your property. And while we're on the phone, I can look at an aerial view of your parcel and I can see shaded in red along with some source document plan sheets. And we can have an intelligent conversation within a few minutes of us reaching each other on the phone about what I believe the impact to your property will be and how we may be able to help with that. Secondly, and perhaps most importantly, oftentimes potential clients are nervous about or weary of exorbitant or high cost attorney's fees, having to come out of pocket for something like that. At Bell Carrington in our eminent domain matters, we don't charge out-of-pocket retainers. There's no upfront cost due. There's no out-of-pocket cost ever due. In fact, we operate on what's known as a contingency fee basis, which is ultimately a percentage of the amount of just compensation that we're able to recover at our clients that's payable at the end of the case, wherever that may be. And if we're not successful in our recovery for you, then there's no fee due. I can get into the details of that depending on each particular property on a one-on-one basis. If you'd like to reach out to us, I'd be happy to explain how that contingency fee works and how it may work on your particular parcel. So again, just to recap, number one, thank you for joining us. I appreciate you being here, and I hope we've provided at least some helpful general information. But this project is a major project, 2.6, nearly 3 miles of corridor of 107, along with some major intersection improvements along that stretch. That's kicking off now. Right-of-way acquisition is happening or will be happening soon. And so, if you're contacted or if you have any questions or concerns about the impact of your property, feel free to reach out to us. Again, no cost, no obligation consultations. Happy to speak with you to see if you're impacted, and if you are, how we may be able to help. Again, Michael Gault and Lindsay Carrington at Bell Carrington, Price and Gregg with the Eminent Domain Practice Group. We want to thank you for your time here this morning. I look forward to speaking with and hopefully working with some of you in the future. Thank you.